Welcome today to this business leader interview with Greg Latcham's Solicitors. We're joined today by two experts from the firm to give us some help and advice about future planning for your business. Our first expert is Paul Hardman. Welcome, Paul. Paul is one of the company's directors and heads up the corporate and commercial departments. He specializes in corporate finance work covering mergers and acquisitions, management buyouts and management buy-ins, joint venture arrangements and shareholder agreements. Paul has over 30 years of experience acting mostly for SMEs and owner-managed businesses. Paul, thanks for your time today.
Thanks very much, Ollie. Great to be here and look forward to those questions.
Great. We're also joined by Bridget Juckes, who is an associate director in the commercial and corporate law team. Bridget has over 35 years experience in dealing with SME owner-managed businesses, particularly in the care home, hotel and retail sector. Bridget, thanks you too for joining us today.
Hi, Ollie. Thanks very much. It's a great pleasure to be here with you today.
Thank you, Bridget. We'll bring in Paul for the first question. We've reached out to a few of our readers to find out the most common questions they have. With the difficult times we're living through, many people are just trying to get their businesses through this pandemic. Would you say this is a good time to start putting future plans in place? And if so, where should a business leader start?
Ollie, I think that's a very good question. And I think the answer to that is yes. I don't know if you're like me, but I keep my personal papers at home and my work-related papers at the office. But working from home has brought me face-to-face with those papers that I keep at home. And it's given me that chance to reflect away from the office about the business and what it will look like when we get back to the new normal. I mean, for many business owners, I think this is the moment to get away from the grindstone and reflect on the longer-term legacy. So for one of my clients, it's been the moment to reflect on his own mortality and to wonder what would happen if his businesses and how his wife would get on if he wasn't there to run the business. So in his case, it meant having a quiet word with an old friend, and he asked him to take over the chairman role with support from me as the company lawyer. And we put in place various measures to help him do that in a fairly efficient way, and we'll talk a little bit more about that as we go through. I would start this process by looking at the business and assets. So there are many good tax reasons to split trading assets and investment assets, but those tax differences also underline the qualitative differences between trading and investment assets. So as a broad generalization, I would say you can think about trade involving that high degree of risk, backing yourself to succeed, whereas investment is more about taking a measured risk, often with a number of beneficiaries. So if you think about the family-owned company, especially if you think about your family and your family members, how you arrange those assets can help address different family members' personal strengths while maintaining that broad fairness that all family members will want to keep. To give you a very brief example, we were involved in a demerger recently where the business had a substantial asset, in this case, a freehold property warehouse just south of Bristol. And we had to take that out of the group and put it into a separate entity before we could then address the family's requirements for the remaining rather smaller business that was left. And once we'd done that, we were then able to make progress.
Thank you for that answer there, Paul. We'll go over to Bridget now. This is an interesting question that one of our readers have asked. How do we deal with different types of shares and the people who hold them?
Yes, indeed. A company can have a share capital that consists of more than one class of shares. This can be a really useful tool within a company to allow a number of groups of shareholders to have different rights attaching to their shares. The most usual way in which classes of shares can be distinguished is between voting and non-voting shares. And so that can be used where there's a requirement to allow one group of shareholders to benefit from dividend income on their shares, but where it's not appropriate for those shareholders to take part in the decision-making process at shareholder meetings. So they'll very often be used in family companies for proper tax planning purposes to allow dividend income to be paid to family members who may not have other income and can therefore take advantage of tax-free personal allowances to extract money from the family company. Also, with different classes of shares, it's possible to declare different levels of dividends across the different classes, perhaps to recognise different levels of contribution to the running of the business. Another refinement is that you can have preference shares so that the holders of that class of share are entitled to dividend before the other classes of shares. And you can even provide for a fixed level of dividend, subject always to availability of appropriate distributable profits, which can be useful, for example, where you've got an outside investor who's looking more for a fixed level of return on their investment. Using different classes of shares can allow for some creativity within what can sometimes be seen as the rather rigid company structure. So we've recently dealt with a family company where it's very important to the family to keep control and direction of the company within the immediate family. So in that case, we created a share structure under which only direct bloodline descendants of the founder of the company who actively worked in the business of the company were allowed to hold voting shares. So where a company has different classes of shares, you do need to give thought to a number of issues arising out of that. So what happens if a shareholder of shares of one class wishes to dispose of their shares, whether by way of gift or by selling them to a third party? What happens, you might have provisions in place requiring a shareholder to dispose of their shares in certain circumstances. For example, they cease to be involved in the business on a day-to-day business basis. Or what happens if a shareholder dies? So in any of those circumstances, do those shareholders or their personal representatives have to dispose of their shares, or can they keep them? If they're obliged to dispose of them, it needs to be decided whether it's preferable that shares of one class can only be transferred to holders of the same class of shares. So that, for example, would be appropriate where you have different classes of shares held by different family groups, for example. So you could keep shares within the same family. And then moving on from that basic principle, can shares pass without restriction within that class, or must the shares be offered round to all the other shareholders in that class? Another way forward might be to decide whether shares could perhaps be converted to a different class of shares. So in the example I mentioned above, in that case, if a holder of voting shares ceased to work in the business of the company, those shares automatically converted to non-voting shares. Of course, having gone through all those decisions, you've always got to bear in mind, you've got to consider what happens if gone through those procedures, there's no one who is able or willing to take those shares on, to buy those shares under the rules that you've agreed. Would it be acceptable at that point for the shares to be offered to shareholders outside the relevant class of shares, or indeed ultimately to a new shareholder altogether outside the company? And the final default position is that it may always be possible for a company to buy back the shares itself, in which case those shares would be cancelled.
Brilliant. Thank you for that answer, Bridget. Paul, we'll come back to you for this next question. How important is it to have a shareholders agreement in place, and what other legal documents do business leaders need?
Ollie, yeah, I think a shareholders agreement is valuable, not just as for the legal document, but for the process that you need to go through to produce the agreement, where issues are discussed and debated and resolved, and everyone then knows where they stand when it comes to those important issues affecting the life of the company. So it covers the management of the company, voting levels for key decisions, the dividend policy of the company, relationships between the shareholders, in particular, what will happen if one of the shareholders decides he or she wants to sell, when the shareholder is compelled by the agreement to sell, and what happens if some only of the shareholders want to sell to a third-party buyer. So just looking at some of those items in a bit more detail, and typically shareholders will have rights of preemption, as Bridget has suggested there, with shares of an outgoing shareholder being offered around to the continuing shareholders, and the continuing shareholders or the company itself having the right but not the obligation to buy out the outgoing shareholder. And then the question arises, at what value? And here the shareholders agreement is very useful at defining how the shareholders regard the investment in the company, whether it is to be on the basis of a proportionate value of the whole company or on the basis of the value of the shares as a separate tradable asset. And if it's a separate tradable asset, the value of the shares will be at a discount if those shares represent a minority, or at a premium if they represent a majority of the shares. For a relatively small share, say 10%, the discount can be in the region of 80 to 90%. So getting this right will be hugely significant. Another significant issue to address is whether the shareholding is linked to a continuing role in running the company, or more generally in the success of the company. And if there is that link, then the shareholder who leaves the company can be expected to require to sell their shares to the other shareholders when that happens. And, again, a hugely important principle to understand here and to discuss, and it will involve balancing the needs of the company's management to keep a tight control of the company and to be rewarded for their energy and drive and entrepreneurial flair against the value that the shareholders want to retain for a future sale, i.e. their investment value, if you like. The shareholders agreement may also address the rights of some of the shareholders, for instance, an agreed majority to require the other shareholders to join in the sale to a third-party buyer, what are known when you get into the detail as drag-along and tag-along rights. Again, a hugely significant question, and not just for the shareholders, but for your would-be buyer, who'll want to know that if it comes to it, the minority shareholders can be asked to come along on a sale. Other issues that the shareholders can address or will address are the rights to issue more shares, and therefore the rights of the shareholders to prevent their percentage being diluted, or at least having the opportunity to subscribe for more shares at the same price as they're being offered to others. Beyond that, the shareholders agreement can cover any number of issues as agreed by the shareholders. And certainly I would say that no two shareholders agreements are absolutely identical. But here is a flavor of some of the other things that typically shareholders will cover. So management responsibilities. So one area could be the management of the company, including the roles and responsibilities the shareholders will have as directors and employees of the company. And these often are accompanied by employment contracts, which will further define those roles and responsibilities and become particularly important in the context of the shareholders agreement if the shareholder is required to sell his or her shares when he or she leaves. And typically, provisions in shareholders agreement may address issues around price in those circumstances, with a discount on price depending on the circumstances of that person leaving. So other issues can include governance, that is board meetings and how board meetings are to be held, and frequency and notice provisions, etc. Voting controls, and this is another key area. By company law, a company is controlled by a majority of ordinary shareholders, therefore meaning just over 50%. Some resolutions require 75%, such as changing the Articles of Association, disapplying preemption rights on issue, and liquidating the company. But the shareholders agreement can determine key decisions, what those are, and what the specified majority will be to pass those resolutions. So I've mentioned dividend policies, that's another key area, shareholder loans and shareholder restrictions. And these shareholder restrictions are where the shareholders are constrained from competing with the business of the company while they hold shares and for a period afterwards, and similarly from seeking or accepting the business of customers or poaching employees and consultants. So what about if you already have a shareholders agreement? Is any of this relevant to you? Well, I think it still is, because it's a good time now to have a look at your existing shareholders and shareholders agreement to make sure it covers these points. And if you have cross-option agreements, and quite often I haven't talked in detail about these, but if you've got them, you'll know you've got them, and they are linked to insurance policies. Now is a good time to review them. The insurance policies will pay out in the event of an insured event occurring, such as incapacity or death. So the idea is that the cross option will allow those shares to be bought out, and the insurance policy will provide the means to do that. So this is a good moment to have a look at the value of the company in today's market, and it may produce a reassessment of the premium that's payable on those insurance policies and an amendment of the buyout price. So you asked about what other documents. Well, I would certainly say have a look at the Articles of Association. You may need to adopt specific Articles of Association, and Bridget's answer that she just gave about different classes of share tells you how they can be used as part of the mix, and you will need specific articles to create separate classes of shares. I would also consider updating your Articles of Association if you've got pre-2006 Table A regulations. And for anyone who's been following my guidance on the Greg Latcham's website, you'll see that I refer to the holding of virtual board meetings at this time. So one point to note here is that the pre-2006 Companies Act articles do not specifically refer to the holding of remote board meetings. So if you are holding remote board meetings via Zoom or such like, now is a good time to adopt those 2006 model articles. Thanks, Ollie, back to you.
Brilliant, thank you, Paul. Bridget, we'll bring you in again for this next question. Unfortunately, with the pandemic we're living through, this question is surrounding a difficult situation that many people will be experiencing. What happens if a director or shareholder becomes incapacitated or dies?
Yes, of course, this is something which we've been giving considerable thought to over the past weeks, because it really has highlighted these potentially problematic scenarios for businesses. These sort of things are always difficult things to think about, particularly for new companies. But the current crisis has shown us that the unexpected does happen. And unfortunately, if advanced thought and planning hasn't been put in place, appropriate procedures, in worst case scenario, it could even mean that the court has to be involved to resolve matters. The good news is, however, that particularly now when business owners perhaps have a little more time to sit back and think about the underlying structures of the business, there are things that can be done to provide a sound basis for the business in the unfortunate event of death or incapacity. So if we take the least complicated issue first, what happens if a shareholder dies or becomes incapacitated? A person's shareholding is a personal asset which will, unless something else has been agreed, pass with their estate. So under their will, or if there isn't a will in place, under the intestacy rules. And that can be particularly difficult in a company where the shareholders and directors are the same people, as it can mean that a surviving director shareholder is left to run the business without the assistance of their colleague, while the beneficiaries of that departed colleague who inherit their shares take the benefits in the form of dividends or any capital growth moving forward, which is solely attributable at that point to the hard work of the surviving director shareholder. I have acted for clients in the past where that's actually been something that they were happy to happen and would wanted to happen should either of them die. But it does need to be thought through so that it's a positive decision rather than a default solution. If you're thinking about what would happen to your own family, it's important to remember that there's never any guarantee of a dividend being paid to a shareholder. So there's no guarantee of any ongoing income to the shareholders. So in that case, would it be better for the survivor to have the right to buy the shares of the deceased shareholder? That would obviously also mean that the family of the deceased would be able to realise the value of the shareholding, thus freeing up cash for living expenses and so on. I'm very often quoted as saying to clients, you can't spend shares in the supermarket. That does, of course, raise the issue of how that purchase could be funded by the survivor. And this can be covered by way of insurance policies, as Paul's already mentioned. Same considerations really apply in looking at cases of incapacity of shareholders. Does the incapacity again trigger an offer round of shares to the shareholders who are still active in the company? If a shareholder is incapacitated, their rights as a shareholder can be exercised by an attorney, subject always to any contrary provisions in the Articles of Association of the company or any shareholders agreements. But that is something which has to be put in place before the incapacity has risen. So something to think about now rather than later. Moving on to what happens if a director dies or becomes incapacitated, the company can continue under the direction of the other surviving directors, but in cases, which is very often the situation with small family companies, the deceased director may also be the sole director and sole shareholder. And then you've got a problem because there's no one in situ with appropriate authority through whom the company can carry on acting. So it's important to check that you've got provisions in place under the company's Articles of Association or a shareholders agreement, which set out who has the right to appoint a director in those circumstances. How can the company's business continue in the absence of an incapacitated director? It's not possible for a director to delegate their decision-making authority under company law, but it is possible, and it might be worth considering appointing an alternate director, someone who would step into their place for as long as the incapacity continues. Those arrangements have to be put in place on a contingent basis to become effective in the unfortunate event of the incapacity, but it is something that you could put in place and then know that you have that basis there should the worst happen. It's easy enough to decide to think about such things later, or when we've got a bit more time, or even just to decide that, oh, it's okay, we're young and healthy, what can happen? But I speak from experience when I say that even before COVID-19, it's always been worth having these discussions and putting procedures in place to protect your own position and that of the company. I once acted for a relatively new but thriving company with young and energetic director shareholders. One shareholder went on a marvelous water sports holiday on the other side of the world, unfortunately suffered a catastrophic injury and was left seriously incapacitated and unable to work. Fortunately, they had been to see me a little while before. We had put a shareholders agreement in place, and we were able to use the provisions in that shareholders agreement to enable the remaining director shareholder to buy his colleagues' shares and enable the company to move forward, whilst also then providing the funds to provide for the ongoing living expenses and care of the incapacitated director shareholder.
Brilliant. Thank you, Bridget. Paul, back to you for this next question. When should I start thinking about succession planning, and what are the key issues to consider?
Ollie, I think succession planning is a huge subject, and I won't do it justice in this short answer I have for you, but let's look at it in a broad context. If we think about your successor, that might mean your buyer of the business. And if you're thinking in those terms, I would always recommend that you start thinking about selling 2 or 3 years before you're ready to put the business on the market. And it will take that sort of time to get your business up and ready and fighting fit for the best price. But if you're thinking of selling to a management team, the compulsion to maximize on value up to the date of sale is not quite as urgent, as the management team can and will carry on the plans you have for the business for a number of years after you have sold. So the sales structure allows a more gentle handover. If you have family members in mind to take over the business when the time comes, it's a personal matter for you as the owner of the business, and for your family members as your potential successors, considering their age, their experience, their position in the company, your own attitudes towards their involvement in the company, its success, and your future in it. However, I would say that it's never too early to start planning, and there are many intermediate steps that can be taken to start the process and to start involving family members in a contained way, if that is what you want, until the time comes for them to take a fuller role. So one of the cases that we dealt with, we had, if you like, a grandfather, a father, a son, and a daughter, all those generations with different classes of shares having a stake in the company. As for the key issues you ask about, that is difficult. Everyone is different and is motivated by different things. Perhaps I would suggest to define what success looks like to you. And one of the things you can do is actually write this down in your business life plan. And with family business, I think that involves asking yourself whether it is the money that the business produces that defines your success, or the difference that the business itself makes to its community, or the involvement of the team around you that makes that difference, or some other facet. These are very personal issues, and I would not say any more than thinking these things through helps not just yourself define your own goals, but will help all those around you, that's family members, management team members, and fellow shareholders, to create a better understanding. And finally, I would say it is important, once that process is complete, that your wishes are known and recorded. It may seem an obvious point, but it is no good keeping these thoughts in your own head, where they will die when you go. Thanks, Ollie.
Thank you, Paul. Some good insight there. Our final question of the day will be for Bridget. Once I've considered all the issues and made decisions about the future of my business, how do I bring all those details together? And do I need to involve a solicitor?
Yes, we've already discussed really that it's not always easy to look ahead to plan your exit from your business, whether it's looking at plans to move towards a retirement or a sale, or whether you're looking at what might happen in the event of your death or incapacity. But it can be seen as a positive step towards ensuring a solid basis for your company in the event of a sale or should the worst happen, so that you can protect the interests of the company, its shareholders and employees, and to put the thing in as strong a position as possible. Paul's mentioned putting together a business life plan that's setting out how you would ideally see your business moving through its life towards your ultimate retirement or sale of the business, or what you'd like to see happen in the event of your death or incapacity. You will obviously have ideas of your own as what you would like to see happen, as Paul has said, and it's definitely worth seeking professional advice from your accountant, your financial advisor, and your solicitor, as they'll be able to put the structure around what your intentions and wishes are, but they may also be able to suggest other areas and possibilities that haven't occurred to you as yet. And your solicitor would then be able to encapsulate your wishes and your intentions into appropriate documentation. So that would be the Articles of Association or Shareholders Agreement, to make sure that all the documentation is in place to reflect what's intended. Thank you.
Thank you very much, Bridget, and thank you for answering these questions today. You've given some great answers, and I'm sure they'll be very helpful to our viewers. Paul, thank you too for your time and expertise today. Lots for our readers to take in and consider. If someone is ready to discuss future planning and in particular shareholder agreements, how can they get in touch with you?
Thanks, Ollie. Just to direct them, please, to the Greg Latcham's website, which is www.greglatchams.com.
Thank you very much, Paul. Thank you.